ল ব্যারেট রেজিস্টার্ড আইনি প্রতিষ্ঠান। আমরা সুপ্রিম কোর্ট, হাইকোর্ট, জেলা কোর্ট, ক্রেতা সুরক্ষা আদালত এবং ভারতবর্ষের প্রভৃতি কোর্টে যে কোনো আইনি সমস্যায় আপনাদের পাশে আমরা সর্বদা। ল ব্যারেট ল ফার্মের তরফ থেকে আজকে যে ভিডিওটা দেখানো হবে সেটা খুবই একটা ইন্টারেস্টিং ভিডিও, তাই জন্য অনুরোধ করা হচ্ছে ভিডিওটা স্কিপ না করে পুরো ভিডিওটা দেখার জন্য। স্কিপ করলে আপনাদের বুঝতে অসুবিধা হবে। আর এই সংক্রান্ত অন্যান্য ভিডিও সবার আগে আপনাদের স্ক্রিনে দেখতে কিংবা অন্যান্য সংক্রান্ত ভিডিও জানার জন্য আমাদের কমেন্টস বক্সে কমেন্ট করুন। আর এই সংক্রান্ত যদি কোনো অসুবিধা হয় তাহলে অবশ্যই আমাদের স্ক্রিনে দেওয়া নাম্বারে, যেগুলো 033796035549, 9831149393, 7003431764, 6289768070, কিংবা ইমেল যেটা রয়েছে lawbarrett007lawfarm@gmail.com সঙ্গে যোগাযোগ করতে পারেন কিংবা অফিসেও ডাইরেক্ট যোগাযোগ করতে পারেন। Today's subject is, can a registered conveyance deed be cancelled by mutual consent? A typical conveyance and sale document is a complete transfer and an executed contract wherein no balance payment remains to be paid by the parties. A conveyance deed once executed by the vendor transfer all his right, title and interest in a movable property under the purchaser, and the document itself records that the purchaser shall use and hold the same forever, and possession is also handed over to the purchaser. Therefore, vendor himself does not retain any other rights, unlike it in case of lease or mortgage, wherein the mortgagor and the lessor retain certain rights, with them vice versa the property. However, unlikely it may seem that once the conveyance is executed there cannot be any cancellation thereof. Still, there are instances of cancellation or attempts of cancellation of such complete documents of conveyance executed between the parties. Under Section 5 of the Transfer of Property Act 1882, it is provided that transfer of property is performing of an act whereby a living person conveys the property. Sale is also defined under Section 54 of Transfer of Property Act, which means transfer of ownership in exchange for price. It is not mandated under the Transfer of Property Act that for sale to take place, the entire price or consideration has to be paid. A sale under Section 54 of Transfer of Property Act includes within its scope transfer of ownership rights in exchange for price promised to be paid, part paid and part promised. In the matter of Latif Estate Line India in Limited and others versus Hadija Amal and others, the aforesaid aspects around cancellation of conveyance were thoroughly discussed. It was the case of respondent that she had paid the consideration payable under registered sale deed executed in her favor and had been put in possession of the immovable property purchased thereunder. However, after almost 10 years of registration of sale deed, the appellant being vendors therein registered a unilaterally executed cancellation deed. The matter to the cancellation of execution deed, the matter was decided by a single judge, wherein it was held that since unilaterally cancellation deed was executed without consent of other party and same did not comply with requirements of Section 32A of Registration Act, such cancellation deed was quashed and appeals were filed challenging the said order. After that, it shows that an amicus curiae was appointed by the court. It was pointed out how a conveyance is different from any other transfer under Transfer Property Act, and the peculiar aspects of conveyance which need to be considered while deciding the matter regarding cancellation thereof. Since a sale of immovable property by a conveyance sale deed creates right, title or interest and is for value of rupees 100 or more, the same require compulsorily registration as per section 17B of Registration Act 1908. As regards unliteral deed of cancellation as per section 62 of Contract Act 1872, it is required that to rescind any contract which does not require any further performance from parties. All the parties therein must agree and execute new contract rescinding the old one. The court observed that the cancellation deed also ought to be executed by all parties to original sale deed. The Specific Relief Act 1963 under section 31 also provides remedy for cancellation that person against whom a written instrument is void or voidable and who has reasonable apprehension that such instrument if left outstanding may cause him serious injury may sure to have it adjudged void or voidable, and the court may, in its discretion, so adjudge it and order it to be delivered up and cancelled. There is no provision either in the Transfer Property Act or in the Registration Act which deals with cancellation deed of a sale. The court observed that it could be due to the reason that since the vendor has already transferred all that he had unto the purchaser, a cancellation deed, even if registered, would not create, assign, limit, or extinguish any right, title, or interest, and hence such cancellation deed would have no impact in the eyes of laws. Conclusion by the court, that is, a deed of cancellation of a sale unilaterally executed by the transferor does not create, assign, limit, or extinguish any right, title, or interest in the property and is of no effect. Such a document does not create any encumbrance in the property already transferred. Hence, such a deed of cancellation cannot be accepted for registration. Once title to the property is vested in the transferee by the sale of the property, it cannot be divest into unto the transferor by execution and registration of a deed of cancellation, even with the consent of the parties. The proper course would be to reconvey the property by a deed of conveyance by the transferee in favor of the transferor. Where a transferor is effected by way of sale with the condition that title will pass on payment of consideration and such intention is clear from the recital in the deed, then such instrument or sale can be cancelled by a deed of cancellation with the consent of both the parties on the ground of non-payment of consideration. The reason is that in such a sale deed, admittedly, the title remained with the transferor. In other cases, a complete and absolute sale can be cancelled at the instance of the transferor only by taking recourse to the civil court by obtaining a decree of cancellation of sale deed on the ground inter alia of fraud of or any other valid reason. There are instances where parties may mutually decide to cancel a registered conveyance either because the purchaser is unable to make payment of the balance consideration or for other reasons such as not obtaining necessary permission from concerned authority or when a third party right or encumbrance in the property comes to light subsequently. Latif Estate line only gives an illustration of non-payment of balance consideration. However, in this author's opinion, the ratio referred to in clause 3 above would apply to breach of any representation covenants provide the parties express their intention that such breach would amount to title not being passed to the purchaser. Such cancellation deed may lead to situation where a seller would, in conclusion with a purchaser, temporarily create rights in favor of a purchaser and subsequently cancel the same to play fraud on local authorities, financiers or other third parties. In order to avert such a situation, it is necessary that a time limit be prescribed within which parties can execute such cancellation deed as currently in aspect to be open-ended. The ratio in Lati vested lines surprise also leaves open certain issues relating to stamp duty on such cancellation. Initially, it may seem harsh to make parties pay stamp duty at the same rate once again at the time of cancellation. However, consider the following scenario. In a English mortgage, a party taking a loan mortgage to the security property by way of conveyance in favor of the lender, and when the loan is repaid, the security property is conveyed to the mortgager. The stamp duty is paid twice on the conveyance from mortgager to lender and on the reconveyance from lender to mortgager. As per the ratio Latif estate line, Supra is it appears that such reconveyance would not be required and a simple cancellation deed would suffice. This thus, if a cancellation deed entails a nil or nominal stamp duty, the parties can save on the entire stamp duty which they would have paid on such reconveyance. It is high time that Transfer Property Act, Registration Act and Stamp Acts of respective states provide for legality, effect and implication on such cancellation deed in order to remove these ambiguities. থ্যাংকিং ইউ অল। ল অপারেটের তরফ থেকে আজ যে ভিডিওটা দেখানো হলো সেটা দেখার জন্য সকলকে ধন্যবাদ। ভিডিওটা ভালো লাগলে অবশ্যই লাইক করবেন, সাবস্ক্রাইব করবেন চ্যানেলটা এবং প্রচুর শেয়ার করুন যাতে করে অন্যান্যরাও দেখে উপকৃত হয়। এই সংক্রান্ত আরও যদি ভিডিও দেখতে চান কিংবা ইনফরমেটিভ ভিডিও কিংবা লিগাল অ্যাওয়ারনেসের উপর যে ভিডিওগুলো আমরা আপলোড করি সেগুলো দেখতে চান তাহলে অবশ্যই চ্যানেলটাকে সাবস্ক্রাইব করুন এবং যদি অন্যান্য বিষয় জানার থাকে কিংবা এই বিষয়ে জানার থাকে কিছু তাহলে কমেন্টস বক্সে কমেন্ট করবেন। ধন্যবাদ।